Hello, everyone. Thank you for joining us for today's webinar, Financial Risks, Common and Employee Benefit Programs. Before we begin, I want to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these during the webcast, but if a fuller answer is needed or we run out of time, it will be answered later by email. A copy of today's slide deck, as well as other reference materials, are available in the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. This webinar is CLE accredited in California and Illinois for 1.0 hours of general credit, and in Missouri for 1.2 hours of general credit. We award CLE based on attendance for the entire 60 minutes. From time to time, you will be required to click a pop-up screen to reflect your continued engagement. Your certificate of attendance will be emailed to you later this afternoon once your attendance has been verified. Thank you for participating in this course. So with that housekeeping out of the way, we'll go ahead and get started. Introduce myself. I'm Mike Lane. I'm a partner in Thomson COBRA's Employee Benefits Group.
And I'm Trish Winchell. I'm also a partner in Thomson COBRA's Employee Benefits Group.
So what we're hoping to present to you today are a variety of topics where companies can get into financial trouble or risk penalties based on some common scenarios in operating their employee benefit programs. And so Trish and I will sort of pass things back and forth as we go through these topics, but feel free to submit questions as we go. First topic we're going to address are some recent case laws regarding potential penalties that employers might face for COBRA mishaps. So COBRA, as you know, has a statutory scheme. I'll give you a 10,000-foot overview rather than get all into the weeds here. But basically, what it boils down to is that group plans are required to offer continued coverage when somebody's health coverage is lost due to a qualifying event. There are notice requirements imposed on plan administrators, and there are various penalties for non-compliance with these rules, including excise taxes, statutory penalties, and potential lawsuits by aggrieved parties who are damaged by failure to follow these rules. So what we're going to be talking about today include recent case law, Morehouse versus Steak and Shake, some Florida class action litigation, and some litigation concerning documenting your COBRA notice compliance program. Let's start things off with Morehouse versus Steak and Shake, a recent case that came out of Ohio. Rebecca Morehouse was working as an assistant manager at Steak and Shake. She enrolled in health coverage for herself and for her husband. Unfortunately, she suffered a knee injury at work and she was unable to perform her duties. She was granted a leave of absence by Steak and Shake and received workers' compensation. The leave of absence was granted under FMLA, and it ran concurrently with the workers' compensation. Premium payments for her continued participation in the health program were deducted from her workers' compensation. So key facts of the case include that the leave began on May 26, 2013. Her FMLA expired on August 19, 2013. Workers' compensation payments to her continued through the payroll period ending August 27, 2013. In addition, the Steak and Shake plan provided continued eligibility during leaves of absence, not just FMLA leaves of absence, subject to continued payment of the premiums. Finally, the last workers' compensation check that she received was insufficient to cover the full premium for her coverage. So, Steak and Shake sent her a notification of this shortfall and the amount needed to maintain her coverage. But she was not provided with any information regarding COBRA coverage. So ultimately, having not paid the premium, her coverage under the health plan was terminated, and when she was unable to return to work, her employment with Steak and Shake was terminated in February of 2014. Because she needed surgery, she went out on the private market, purchased insurance, and underwent surgery for her knee injury. She ended up filing suit against Steak and Shake in 2016, alleging violations of the COBRA notice rules and a breach of fiduciary duty by Steak and Shake under ERISA. The Southern District of Ohio granted her summary judgment. They found that Steak and Shake was liable for damages, including Morehouse's medical expenses, less any premiums she would have owed to Steak and Shake for COBRA coverage. The court also awarded her statutory damages for failure to provide a COBRA notice. The court ended up awarding $50 per day that the notice was not provided, but they could have awarded up to $110. Finally, they also ordered Steak and Shake to pay Morehouse's attorney's fees. And while this decision was ultimately overruled, it's still instructive for employers to think about how they operate their COBRA compliance under their health plan. The reason that it was ultimately overturned is that she was still eligible under the Steak and Shake plan during her leave. Coverage was not terminated due to a qualifying event. It was rather terminated because she failed to pay the premiums. But what if she had lost eligibility once her non-FMLA leave started? That would be a very common plan design, and under the circumstances, that would have resulted in COBRA being required to be offered to her at that time. And if Steak and Shake had not done that, or if your employer plan does not do that, you could be in the same position as Steak and Shake was at the district court level. Next topic concerning COBRA compliance is a rash of COBRA class actions that have been filed in Florida. And while these have been filed in Florida, and you may or may not have operations in Florida, Florida and California tend to be places where precedents are set and plaintiffs' firms take their cue from how courts respond in those locations. So the potential penalties that I described above relating to the Morehouse case also apply to deficient notices. And in order to be a sufficient notice under COBRA, the notice has to be calculated to be understood. It has to contain certain contact information for the responsible COBRA administrator, and it has to include basic information like a description of the coverage, how to elect it, what dates the coverage is available, and any requirements concerning payment. So a number of plaintiffs' firms are filing these class actions, alleging that one or more of these technical violations are not met. They're asking for damages. Some of these cases allege that English-only notices are insufficient to be understood by Spanish-speaking groups. And just as an example, SunTrust Bank faced one of these class action lawsuits. They attempted to dismiss the case on summary judgment. That was denied. Ultimately, SunTrust Bank agreed to a $290,000 settlement with the class. And when you think, boy, how did they get that high with a $110 penalty? Well, it's $110 per day per person. If you think of a large institution like SunTrust that may have locations throughout Florida, those penalties can ramp up pretty quickly. Finally, a recent case demonstrates the need to maintain documents that are sufficient to demonstrate that you sent COBRA notices. Randolph versus East Baton Rouge Parish School Board was a 2019 case. A former employee claimed that the employee did not receive any COBRA notices from the school board. The employer argued that its standard process was followed, but could not produce any documents proving that a COBRA notice was sent. The employer filed for summary judgment, and that motion was denied, and the case has been set for trial. So important takeaway from this is that you do not need to prove that the COBRA notice was actually delivered to the individual, but you do need to keep documents sufficient to prove that the notice was actually sent. So key takeaways from the COBRA-related potential issues for your employee benefits compliance. Consider using the Department of Labor's model COBRA notice, but you'll need to modify it as needed to include plan-specific information. You'll also want to consider the need for any non-English notice or assistance with COBRA coverage. You'll also need to maintain adequate records to prove the COBRA notices were sent. And if you use a vendor to assist you with your COBRA process, ensure that the vendor's notice is accurate and that there are procedures in place to document those notices. And if the vendor is taking on responsibility for you, you'll want to ensure that your contract provides you with adequate indemnities for any failure by the vendor. Trish?
Thanks. Okay, our next topic is missing retirement plan participants. I think missing participants are an issue, at least to some extent, in every qualified plan that's been around for more than a few years. You have a participant with a vested benefit who terminates employment, and eventually a routine mailing to that participant is returned with a bad address indicator, or a letter that requires action is not responded to, and even a benefit check may go uncashed. At that point, the plan probably has a participant entitled to a benefit, but does not know how to contact the participant. This is a problem for the plan administrator independent of government action. Most plan administrators want participants to get the benefits that they're entitled to. But the IRS and the Department of Labor and the Pension Benefit Guarantee Corporation have all recently been increasingly focused on the problem of missing participants in qualified plans in particular. And the IRS and the DOL in particular are concerned that plan sponsors are just not doing enough to locate participants entitled to a benefit, and they're using the enforcement tools at their disposal to push plan sponsors into doing more. Unfortunately, neither has provided definitive guidance or consistent guidance on exactly what those administrators have to do, which can put plans into a bind and risk penalties, cause them to risk penalties without really understanding how to avoid them. The IRS interest is on really the timely payment of required minimum distributions. As you probably know, plan participants can't leave money in a qualified plan forever. Under the Internal Revenue Code, once they reach 70 and a half or 72 beginning this year, they have to begin a distribution. And the consequences for the failure to comply are fairly significant. For the individual, the failure to take a distribution triggers a 50% excise tax payable by the individual. And for the plan, the failure to distribute the required minimum distribution is a qualification issue, and it's reportable on the Form 5500. Because this happens from time to time, there is an approved correction, an IRS-approved correction under the Voluntary Compliance Program, which calls for making the payment, making the distribution, adjusting it for earnings, requesting relief for the individual from the excise tax, and making a filing under the Voluntary Compliance Program, which involves a fee of up to $3,500 depending on the size of the plan. But what if the plan can't find the person? There's really no exemption in the statute or regs. It's not a use your best efforts kind of thing. And the IRS has historically sent on its webpage that contains the instructions for the 5500 that an unpaid required minimum distribution for a missing participant doesn't have to be reported there if reasonable efforts to locate the individual have been made. What are reasonable efforts? The best guidance is probably in an IRS memo from 2017, which is a memo to its examiners, and that memo prohibits the examiners from challenging a plan's qualification based on a failure to distribute a required minimum distribution, as long as the plan has taken some specific steps to locate the individual. And what a plan is supposed to do under that memo is to search internal records. That means going beyond the plan records and looking at other company records that may be a source for contact information for the missing participant. And the plan must also look through publicly available records for contact information, online telephone directories, for example. The sponsor is supposed to use a commercial search service, which are available and which many of your TPAs may have contracts with. And the plan must also attempt contact by certified mail to the last known address and by email or phone if contact information, even outdated, is available for those. While specific guidance to the plan we think would be better, if a plan administrator takes these steps, we think that draconian consequences of an RMD violation should be avoided, and the ability to correct should be preserved, at least as far as the IRS is concerned. But the DOL is also focused on lost participants, and they may be a different matter. Their audit efforts are increasingly concentrating in this area, and their position is that a failure to locate a participant who's entitled to a benefit may be a breach of duty under ERISA. So in the DOL's view, a required minimum distribution violation, which is historically a matter that's solely for the IRS, could be an independent breach of duty within their jurisdiction. And so could a failure to make other distributions required to be made by a plan without a participant's initiation, such as a required payout at normal retirement age, if that's what the plan provides. And they also believe that failure to follow up on uncashed checks can be a breach of fiduciary duty. If they find a breach of fiduciary duty, that can trigger penalties and personal liability for the plan fiduciary. The DOL has issued some guidance applicable to locating participants in terminating plans, and it's very similar to the guidance issued by the IRS to its examiners. Involves certified mail to the last known address, checking other internal records of the company, contacting a beneficiary who may be named, using free electronic search engines, and in some circumstances, using other commercial search services. The problem is that guidance strictly applies to locating participants in terminated plans. And auditors of active plans have suggested that other action might be required. And these are individual auditors in the field who have demanded that plan sponsors may contact coworkers, either current employees or former employees, who they think may know where the lost participant is. We had word of one auditor who suggested that the plan send someone to the last known address and contact former neighbors to see where the lost participant might have moved. Auditors have suggested targeted annual mailings to all terminated vested participants, tracking their addresses, and other communications that are clearly not required by ERISA. And so there's no consistency, and yet auditors have attempted to impose penalties based on, these inconsistent views of what the duty of a plan sponsor is. They have attempted to impose the 50% excise tax owed by participants over 70 and a half on the plan, and have also attempted to impose a penalty for failure to follow plan terms when distributions cannot be made as required by the plan. So needless to say, additional guidance would be welcome. As I indicated, the PBGC is also interested in missing participants, but their program only covers terminated plans. And they do have a helpful program there where benefits can be transferred to them, and they will pay the benefit when the participant is found, but that's not available for active plans. So what should plan sponsors do? Adopt policies to minimize lost participants. And this can be as simple as reminding participants, particularly terminating participants, of the importance of keeping the plan informed of changing addresses. They should have a missing participant policy. Determine what will trigger a search. Will it be returned mail? Will it be a failure to respond to mail that should be responded to? How often to conduct a search? I think annually is fairly typical, but it may be fact-intensive. And what methods will you use to search? Clearly, other plan and company records must be reviewed. free search engines must be used? What circumstances will commercial services be used? And will you be contacting beneficiaries listed in the plan or perhaps emergency contacts? You need a policy for uncashed checks. And you should contact the TPA to understand exactly what efforts are currently being undertaken. Most TPAs either provide some kind of lost participant search services, and sometimes they're subcontracted out, but a plan fiduciary should know what's being done and should document efforts in case of an audit. Mike?
Thanks, Trish. Next topic we're going to discuss is how errors related to timing of payments of deferred compensation can be costly. Timing, as they say, is everything. So deferred compensation is a common tool to compensate and motivate employees. But under IRS rules, deferred compensation is defined in an extremely broad manner. Generally, it includes any type of compensation that is earned in one year but paid in a different year, paid later than it's earned. So it's not only current compensation that an employee elects to defer. It can include things like deferred bonuses or certain forms of severance. So it's more than a formal SERP program or a formal traditional deferred compensation program that can fall under these rules. Taxation of deferred compensation is heavily regulated, and the rules are not at all intuitive. As we're talking about here, the infamous rules under Section 409A of the Internal Revenue Code. So rather than get bogged down into a comprehensive description of 409A and all of the potential problems that you could bump into, what we want to do here today is to highlight some examples of the impact of the rules rather than do a comprehensive deep dive into 409A. Things that we've seen in our practice. So why are we worried about it? Well, the penalties can be severe. It can result in immediate taxation of the entire deferred compensation amount, plus a 20% excise tax, plus interest and penalties based on the date that the compensation was vested, which is a complicated concept under 409A. There is an IRS correction program available to fix things, but you have to catch the error quickly, and even then, some penalties might still apply. So when you add it all up, what you've got is a broad application of complex rules with severe consequences and a minimal opportunity to correct. So this is a recipe for risk soup. Let's run through a few examples. Example one is what I call the payroll error. So Big Co has a non-qualified elective deferral plan for its executives. Chief Operating Officer elects to defer half of next year's pay, and he makes that election on the last day for elections, coming right down to the wire. Unfortunately, due to the timing, payroll doesn't implement the election for the first payroll date in the next year. Seems like a little foot fault, not a problem. Unfortunately, under the IRS rules, it's considered an early payment of the deferred amount when that COO gets the full paycheck the next year. That violation, that little violation, missing one payroll, could subject the COO's entire account balance to the tax and penalties. And it only helps if you catch this quickly to use the limited correction program that the IRS has available. Next example, what I call the retirement. So Public Co issues restricted stock units to its executives. And the general rule under the restricted stock unit agreements for Public Co is that employees have to be employed on the vesting date and then they get paid. So that means that it's paid when it's earned and it's not subject to these deferred compensation rules. But Public Co has an exception in its restricted stock unit program for retirement. So if somebody's age 60 and they've worked for Public Co for at least 10 years, they don't need to be there on the vesting date. They can get paid out when they retire. So CFO of Public Co retires and gets paid out immediately of all of the RSUs that were subject to the retirement program. Well, so what, you might ask? Well, the retirement exception brings those restricted stock units under 409A. They become deferred compensation because if that CFO is eligible for retirement with respect to an RSU award, then it is considered vested and it's paid in a year later than it is vested, and it falls under the 409A rules. In addition, because Publico is a publicly traded company, CFO is likely going to be considered a specified employee, one of the top group of employees in the public company. And under these rules, payment of an account of deferred compensation due to retirement must be delayed for 6 months following the retirement. So if you pay out the CFO right away after the termination of employment, that can result in the draconian 409A penalties. And again, the correction program may be able to help you limit those penalties, but you have to catch these types of problems very quickly in order to be eligible to use that program. Example 3 is what I call the severance package. So you hire a new executive, and it turns out that he's just not working out, and you decide that what you're going to do is part ways. And under the terms of a severance agreement, you agreed to pay this executive 12 months of severance plus COBRA premiums so that you part ways amicably and you get a release. This particular executive participated in the company's non-qualified retirement plan. So what can happen here? Well, in this case, the former executive was tagged in the company's HR system as active to help facilitate those COBRA and severance payments. That was the way they set it up. It was easy in the system to tag him that way so that you could continue to comply with your obligations under the severance agreement. Unfortunately, what happened then is that the non-qualified plan record keeper was not notified that the executive was terminated. And the deferred compensation plan, the non-qualified plan, was supposed to pay out on termination. The non-payment of the amount that was due results in a 409A violation. Final example that I want to run through is what I call the consultant. So you've got a key employee, and that key employee decides to retire. He's owed a retirement payment when he leaves the company that is subject to these 409A rules. The company wants to keep his knowledge around, and they negotiate a consulting independent contractor arrangement so that this key employee can spend a couple of days a week helping in the transition. The employee still wants to receive that retirement payment when he terminates employment. So what's the problem here? Well, the key employee's continued service as an independent contractor does not result in a separation from service, allowing payment from a non-qualified plan. Again, this results in a payment that is technically early under the 409A rules and can result in those penalties that we've been discussing. So these are all very common scenarios, things that you can imagine happening within your own company. What do we need to try to take away from these lessons? Consider how your payroll and HRIS systems interact with your non-qualified plans. You're going to want to ensure the accuracy of any payment date and deferral elections made by anyone who participates in a deferred compensation program. And you're going to want to consult with qualified counsel concerning whether any particular compensation program that you maintain is considered deferred compensation and subject to these rules. Trish?
Thanks, Mike. We are going to turn to the Affordable Care Act. The individual mandate may be gone here, but the employer mandate is still in effect and is still being enforced by the IRS. As a brief and very general reminder, the employer mandate applies to employers with 50 or more full-time equivalent employees. And to avoid any penalty, it's also known as the pay or play mandate. To avoid paying a penalty, an employer has to offer coverage that provides minimum value and is affordable, and must provide coverage must offer coverage to 95% of its full-time employees. There are two possible penalties under the employee mandate. There's the A penalty, which is also known as the sledgehammer penalty. And under that penalty, an employer who fails to offer minimum essential coverage to 95% of its full-time employees will owe a penalty that's equal to, in 2020, $2,570 multiplied by the total number of full-time employees the employer has. It will pay that penalty if a single employee gets subsidized coverage from the marketplace. So here, the coverage the employer offers to avoid the penalty does not have to be affordable or provide minimum value. An employer simply has to offer some coverage to 95% of its full-time employees and make that coverage available to them. But because the penalty is multiplied by the total number of full-time employees, it can be a very significant penalty. What's known as the B penalty is less draconian. An employer will owe that penalty if the coverage offered fails to provide minimum value or is not affordable, and those terms are both defined in the ACA. The penalty is $3,860 in 2020 for each full-time employee who goes to the ACA marketplace and receives a subsidy for health coverage. The B penalty imposed can never be greater than the A penalty that an employer would have been subjected to. And I would note here that because the A penalty will be zero for any employer with fewer than 30 full-time employees, an employer who has 50 full-time employee equivalents but fewer than 30 individuals who actually work full-time could be subject to the reporting requirements of the employer mandate, but would not owe a penalty even if they offered more coverage, no coverage. The mandate is enforced based on reports filed on Forms 1094 and 1095. And there are, of course, penalties for the failure to file and distribute reports in a timely manner. Penalties for the failure to file and distribute the reports timely are generally $270 per return. In 2020, those forms have to be delivered to employees by March 2nd and filed with the IRS by March 31st if you're filing electronically, or February 28th if you're filing on paper. There is good faith relief for incorrect reporting, which there has been since the reporting has been required and has been extended against this year. But the IRS is becoming much less sympathetic to vendor issues that result in untimely filings. We saw some of those initially and were able to get waivers for late filings, but apparently the IRS feels employers should at this point have corrected those issues. If the IRS thinks that an employer owes a penalty, they'll send a notice and ask for a response from the employer before they assess the penalty. And most of the penalty notices that we have seen, fortunately, have been triggered simply by a failure to fill out the form correctly. For example, there is a box to check if you have provided coverage to 95% of your full-time employees. The box is not, the question asked is not entirely clear, and some employers leave the box blank, which will trigger a notice that you owe the A penalty. And that's disconcerting, but it's easy to fix by simply advising that you made a mistake in the filing. The most significant substantive issue we see involves employers assessed a penalty because an employee received subsidized coverage from the marketplace and reported that they were a full-time employee, which would trigger the B penalty. Employers will often defend by indicating that the employee in question was not a full-time employee entitled to coverage during the relevant time period. And the IRS, in early filings, would pretty much accept that at face value. The IRS is now apparently looking more into the employer's methodology for determining full-time status, which can be a complicated process. an employee is full-time for purposes of the ACA if they average more than 30 hours a week of work. And there are two methods to determine that status, as you probably know. There's a monthly measurement period, which counts hours each month. It's simple, but because an employer won't know who's full-time till the end of the month, it's really only practical for employers with a very stable workforce who offer coverage to everyone. There is a look-back method, and under that method, someone you know who is going to be full-time at hire has to be counted as full-time for ACA purposes and could subject you to the B penalty if you don't offer that person coverage in a timely manner, and it's not minimum value or affordable. If an employer can't predict whether an employee is going to be full-time at the start of employment, the employer can count the employee's hours for a measurement period under the look-back period, and then classify the person as full-time if the person's averaged 30 or more hours a week. But it only applies if an employer cannot predict whether the employer is going to be full-time, and it won't apply if an employer knows the person will be full-time, but doesn't expect the person's employment to average 30 hours or more per week over the course of a year because the employment's expected to be of short duration. This creates issues in applying the test, particularly in companies like staffing agencies where employees work for many hours for a brief period and then not again for a while, or where an employee is hired for a particular project of limited duration. The analysis can be complicated, and while most plan sponsors and employers have certainly long since established an ACA compliance plan, they may want to relook at the plan, particularly if they have a complicated workforce structure. And given the focus of the IRS on the full-time the methodology used to determine full-time status, employers will definitely want to be sure they have records of how they apply their methodology. The other potential monetary risk posed by the Affordable Care Act is the failure to file with the market reforms. And we'll get into the reforms later, but this penalty can be significant. It's an excise tax imposed by the IRS. It's $100 a day per individual violation, which can certainly add up. There are certain minimums, and it caps out at $500,000 for a violation. It is required to be self-reported on an excise tax form. It can be avoided, basically, if nobody knew that the tax failure, or nobody knew that the failure had occurred, or if the failure is due to reasonable cause and not willful neglect, and it's corrected in a timely manner. There are also potential ERISA penalties for failure to comply with the market reforms and could be subject to participant lawsuits to compel compliance, and participants can obtain damages. The market reforms include requirements like covering children to age 26, prohibiting prohibitions against rescission, no annual or lifetime limits, waiting periods greater than 90 days, wellness program issues, preventive care, claims and appeals, and deductibles and out-of-pocket maxes. Most plans, obviously, were amended to comply with these market reforms at least several years ago. Where we still see compliance issues sometimes are the nuances of which children need to be covered to age 26, how it applies to foster children, just wellness programs, which appear to be changed more often than other plan provisions. So employers will want to be sure that the market reforms are taken into account with any plan amendments and avoid the potential excise tax penalties of 4980D. Mike, back to you.
Thank you, Trish.
Next topic we're going to discuss today is related to 401k plans in particular, and whether you are following the terms of your plan's definition of compensation in making participant contributions to the program. So, overview of this issue. 401k plan is a type of defined contribution plan, and it may seem obvious, but what a defined contribution plan is a plan that defines what the contributions will be. And as it relates to a 401k plan, it's nearly always defined as a particular percentage of compensation, which is a term that is defined in the plan. So what are the risks related to not properly following your plan's definition of compensation? Well, employees would be entitled to receive contributions as they are defined by the plan. This has been a particular focus of both internal audits and IRS audits of 401k programs. The IRS does have a correction program available to allow employers to fix these issues without running into plan qualification concerns. What the general rule is that the employer must contribute half of what the employee had elected to contribute in the form of compensation to the program. This results in sort of a windfall to the employee because they got the cash in the paycheck. It showed up in their bank account. And they also get half of the amount that should have gone into the plan in addition to what they already received in cash. Further, there's the impact of any matching contribution that was missed that the employer also has to make up. And both of these contributions will have earnings on them. One thing that's important to recognize is that catching these issues quickly can reduce some of these windfall contributions that employees might be entitled to, that 50% contribution. Keep in mind that under the terms of many 401k programs, compensation is often defined very broadly. A typical definition might say that it's any wages that are subject to withholding plus any elective deferrals, with some common exclusions from compensation for things such as fringe benefits or moving expense reimbursements or group term life insurance, a lot of things that are in the nature of welfare benefits or non-cash type compensation. So how does this come up? Let's talk through some common scenarios and think about some things to consider as you operate your 401k program. One scenario is the issue of terminating employees and the lagging payrolls. So most employers will pay that final paycheck after an employee leaves and terminates from the company. At that point, usually the employee's termination date has been entered into the payroll system. That last paycheck for pay they earned while they were working is often compensation as defined by the program. But you can bump into a problem if your payroll system cuts off 401k contributions after a termination date has been entered in the system. Something to keep in mind when you're designing or reviewing your payroll system and how it integrates with your 401k plan. Another common issue relates to rules for unused vacation or other leave that gets paid out when somebody leaves. Now, the 401k regulations have some specific rules for how unused vacation or other leave can be treated, but it is increasingly common for various state, local, or even municipalities to require companies to pay employees any unused time off when they leave. And this unused time is frequently included in most common definitions of compensation for 401k plan purposes. So these couple of scenarios we just talked through, this is somebody who left employment, was paid everything that they were entitled to receive, but they didn't get that 401k deferral. It could result in increased liability for the company above and beyond what would have been required to be paid if the employee had simply had that deferral election implemented correctly and on time. Another common scenario is where what I call the left hand doesn't know what the right is doing. And this happens a lot of times with payroll codes. So oftentimes when you transition from one payroll provider to another, your payroll team has to go through and implement an entire host. I've seen pages and pages and pages of different types of payroll codes for different types of pay that an employee may receive. Holiday pay on a Sunday, blah, blah, blah. The list can go on and on and on. The concern can come if your payroll team is not coordinating with the team that runs your retirement program to ensure that the codes that are marked in the payroll system as 401k eligible actually matches what's written into your 401k plan document. These issues come up all the time, and it's something to keep an eye on. Final scenario I want to talk about is there can be a lot of circumstances where your payroll team is running what they call an off-cycle payroll. It's not the normal biweekly or weekly payroll for your employees. It could be for anything from referral bonuses, safety bonuses, some non-cash payments related to a personal use of an automobile, for example. Your payroll system may be only configured to consider doing a 401k feed for on-cycle payrolls. So what happens when you've got an off-cycle payroll and the compensation that's paid on that off-cycle payroll fits your plan's 401k definition of compensation? You could cause employees to lose out on those contributions, and the company could be then responsible for making that employee whole out of its own pocket. So what are the key takeaways for this issue? You've got to make sure that your payroll and HRIS systems interact properly with your 401k plan. Make sure it's done in a rational way and it follows the plan documents. You want to make sure that payroll runs and payroll codes are coordinated and that your benefits people and your payroll people are talking together. Particularly, this is important when there's change in the organization, if there's a change in your payroll system, or if there's a change in your 401k vendor. Oftentimes, when you move 401k vendors, you get a new 401k plan document, and you'll need to make sure that the new definition of compensation in your new 401k plan matches up with how your payroll system is set up. The other change that can happen is how you compensate your employees. Maybe you have a bargaining situation, or maybe you're implementing a new type of commission system for certain sales employees, and you're creating new payroll codes. Ensure that those payroll codes accurately reflect what's 401k pay when you're changing how you pay your employees. Trish?
Thanks, Mike. I'm going to spend the next few minutes talking about the rules for distributing benefit documents, your various duties to disclose under ERISA, and what the consequences of not complying with those rules are. So first, I want to discuss the plan and the SPD. ERISA, by statute and reg, requires a written plan document and a summary plan description for every benefit plan subject to ERISA. The SPD has to be distributed to all covered employees, including covered COBRA participants, guardians of children who are covered under a qualified medical child support order, dependents of a deceased retiree under a retiree medical plan, but no other dependents. There are timing requirements. The SPD has to be distributed to participants within 90 days of the participant becoming covered, within 120 days of the date a new plan is established. Every 5 years if there's an update to the SPD, and every 10 years even if there are no changes to your SPD. There is no filing requirement. Neither the SPD nor the plan has to be filed with the Department of Labor. SPDs used to have to be filed with the Department of Labor, but I think that got a little overwhelming for them, and it's been years and years since they have stopped taking those. And there's no specific penalty for failure to maintain or distribute the plan or the SPD. So why bother? Well, a couple reasons. If a participant asks for a copy of the SPD, if a participant or beneficiary asks for a copy of the plan or the SPD, and does not receive a copy within 30 days of a request to the plan administrator, the plan administrator may face a $110 a day penalty. Now, that is a penalty that is imposed within the discretion of a court. You need to go to court to get that penalty imposed. But I will say that our litigators will say that claims that if a participant has a claim like this based on the failure to deliver a copy of a plan document or a summary plan description, that may be sufficient incentive for a plaintiff's attorney to agree to represent the participant in a benefit claim that otherwise might not rise to the level of a court claim, because these fines can really obviously add up, as we've seen before. The $110 a day penalties can result in significant compensation if the delay is long enough. This particular requirement is also one reason why we urge companies to consider having an individual or a committee as the plan administrator instead of simply having the company. And that's because these requests have to be addressed to the plan administrator under the terms of the regulation. If they're not, there's no penalty involved because the penalty is on the plan administrator. If the company is the plan administrator and a request simply comes in an envelope addressed to company ABC, it may not end up with anyone who actually understands the request or knows what the importance of responding to a request like that. And that's particularly true if for a company with multiple locations where requests may end up at a plant instead of at headquarters where benefits are administered. Whereas if you have an individual or a committee, you're not going to stumble on this type of request because presumably the individual or the individual who receives it on behalf of the committee will understand the importance of complying with a request for a copy of the plan or the SPD or other plan documents. And another reason, another important consequence of failing to have a plan document or a written plan document or an SPD is that the failure to provide an accurate disclosure or an incomplete disclosure of the plan terms can be a breach of fiduciary duty and can result in damages if a participant relies on that failure to disclose or inaccurate disclosure and suffers damages. The DOL can also enforce a breach of fiduciary duty, even in the absence of a specific penalty requirement for distribution of the plan or the SPD. And finally, the ability to defend claims decisions in litigation is adversely affected. First of all, obviously, the terms of the contract to provide benefits with the employee are set forth in the plan document, and there needs to be judges look askance on employers who cannot produce the plan document or the SPD or did not have one in place at the time the claim arose. And secondly, ordinarily in a dispute over a claims decision by a plan administrator, a court will defer to the plan administrator. The review performed by the court is performed under the arbitrary and capricious standard of review. And an administrator's decision will not be overturned unless it is completely unreasonable. Will not get that standard of review absent disclosure of the plan administrator's discretion to interpret the plan in either the plan document or the SPD. The other document I want to talk about for a minute is the annual report on Form 5500. Due 7 months after the plan year end, absent an extension. Qualified plans are subject to it. Welfare plans are subject to it, although insured welfare plans with fewer than 100 participants typically do not have to file. The IRS penalty for late filing is pretty straightforward, $25 a day up to a $15,000 cap. As is typical, the Department of Labor has a multi-tiered penalty structure that's a little more complicated. The maximum penalty is set forth at $2,194 per day per plan, or $800,000 over $800,000 per year. There's no cap on it. I will say that this maximum penalty is unlikely to be assessed absent extenuating circumstances, like you're deliberately not filing the 5,500 in order to cover up some corruption or something. More likely is the standard penalty, which is $300 a day up to $30,000 per year for non-filers. And these are folks who do not file, wait for the DOL to come in and tell them you have not filed and you better get it on file. Or $50 per day for late filers who do come in and file typically before getting a notice from the Department of Labor. There is also a reduced penalty under the Voluntary Compliance Program, and that would be for a large plan, $10 a day, capping out at $4,000 per plan, and for a small plan, also $10 a day, but capping out at $1,500 per plan. This is only available if the DOL hasn't notified the plan that it intends to assess a penalty. And going through this process generally would also result in a waiver of any IRS penalty. So if you look at the potential penalty under the DOL scheme for a plan, one plan, a single plan filed 5 years late, the maximum would be under the maximum penalty, it's a $4 million penalty. Under the non-filer penalty, the person who waits for the DOL to come in and say file, it'd be $150,000. If you go ahead and file but don't use the voluntary compliance process, $91,000, and through the voluntary compliance process, $4,000. The moral of the story, obviously, is if you realize that you haven't filed, use the voluntary compliance program. Sponsors should understand how many plans they have and which plans need to file, which is obvious. Sometimes we see companies who have not filed the 5,500 because they're used not to filing because the welfare plans do not have 100 participants or more. Companies should be tracking welfare plans that are approaching 100 participants and recognizing when there's a need to file. In addition, if you're filing a single 5,500 for all welfare plans, you should be sure there's a wrap document that consolidates all those plans into a single plan. We are aware of instances where a DOL auditor looking at a single 5,500 filing where there is not a wrap document as rejecting that filing as appropriate because it attempts to cover more than one plan and attempting to impose penalties for lack of coverage or for lack of filing all the plans. We thank you for coming today. I don't know if are there any questions?
I believe there is one question. If anyone has additional questions, now would be a good time to submit them. See if we can address the outstanding questions here in the meantime. It's a question about HIPAA compliance and the HIPAA privacy rule. Certainly, if you've got any sort of self-insured health plan, you want to make sure that you understand what your HIPAA compliance obligations are, both in terms of internal policies and procedures and external business associate agreements. We could probably do a seminar on that topic, but it's a good point.
Yeah, and one important thing to remember here in this context about HIPAA is that health plans, benefit plans, can be covered entities themselves, and the plan itself has to have a HIPAA compliance policy and is subject to HIPAA enforcement the same way a hospital or other healthcare provider would be. Not exactly the same way, but is certainly subject.
There's a follow-up question concerning 5500 filings. Governmental plans are exempt from 5500 filings. That's an ERISA requirement that governmental plans would not be subject to, as well as non-electing church plans.
That's right.
Would not be subject to.
The 5500 requirement is an ERISA.
And the same goes for SPDs.
Right. Okay. I think that covers the questions. So thank you for participating in the webinar. Please complete and submit the survey that's going to display at the conclusion. And we invite you to attend our Human Resources Group's April 16th seminar here in St. Louis at the Marriott West, where we'll cover labor and employment and benefits issues. And we also invite you to go to the TC website to subscribe to blogs and view other publications of interest to you. Thank you.